Welcome back to Darnley Cyber Cafe, the show where we sit down with the uncomfortable truth about what's happening in the world of cybersecurity and privacy. Pour ourselves a strong cup and let's talk it straight. Today's episode is one I've been wanting to do since I've heard about it, and this hits close to home. We're talking about Canada. We're talking about a piece of legislation called Bill C-22, and I'm talking about what it really means for you, your family, your data, and frankly, anyone living in a so-called democratic country in 2026. Because here's the thing, when governments say a new law is about catching criminals or stopping terrorism or protecting children, those are very easy words to digest. But what they don't always say out loud is what kind of infrastructure they're building to do it. And infrastructure, once built, has a way of expanding its purpose. So by the end of this episode, you will understand not just what Bill C-22 says, but what it enables. Those are two very different things. Let's talk about it. Let's start with the basics. What is Bill C-22? The Liberal government introduced Bill C-22 as Canada's new lawful access legislation. On the surface, it's framed as a law enforcement modernization bill, a way to help police and security services to track individuals who may be using modern tools like social media, AI platforms, and encrypted communications to commit crimes or threaten national security. The government's argument? Canada is the only Five Eyes nation without this kind of framework. Our legal tools for requiring telecom companies to maintain surveillance capabilities haven't been meaningfully updated since the 1990s. And clearly the internet was different back then. Smartphones didn't exist. There was no WhatsApp, no Signal, no TikTok. So in that narrow sense, they have a point. But as all with any legislation of this type, the devil is always in the details. And the details of the C-22 are significant. What the bill actually does, the three big pillars. So pillar 1, mandatory metadata retention. So your ISP, Internet Service Provider, and wireless carriers will be required to store categories of metadata about your communications up to 1 year. Not the content of your calls or messages, the envelope. Who you've contacted, when, from where, how often, for every single subscriber. Not people under investigation, every single one. This is the equivalent of requiring Canada Post to record the sender, recipient, date, and location of every single letter mailed before anyone is even suspected of anything. Pillar number 2, warrantless confirmation demands. Police gain the ability to ask your telecom provider whether you're a customer without a warrant, just a demand. They can confirm your service relationship without judicial oversight. Pillar 3, compelled surveillance capabilities. This is one that should keep everyone awake at night. The Minister of Public Safety gets the power to issue orders requiring, quote, core providers, a deliberately vague category, to build and maintain surveillance capabilities inside their infrastructure. Backdoors, mandated by a ministerial order, and those orders can be secret. Now, the government also removed one controversial element from the earlier version of this bill, the power to search people's mail without a warrant. This was dropped after major pushback, so they did listen to some extent, but the core architecture we just described, that remains. Now here's where I need to separate what the bill says from what the bill enables. Because in cybersecurity and intelligence work, and I want to be direct about this, the capability you build today defines the power someone holds tomorrow. Think about it this way. The bill says police need a warrant to access retained metadata. Fine. But what stops a future government from changing that threshold? What stops a ministerial order from quietly expanding the definition of a core provider? What stops an intelligence agency from using retained metadata in combination with AI-driven pattern analysis, not to investigate a suspect, but to find one? What if the next government decides that political dissidents qualify as national security threats? The infrastructure to monitor them at scale will already exist. I want to talk about these compelled surveillance capabilities. The Canadian Civil Liberties Association just put it plainly. Companies could be forced to re-engineer their services to build surveillance tools into them. And once that backdoor is built, once that architectural weakness is deliberately inserted into the infrastructure, anyone can walk through it. Not just the RCMP or CSIS, foreign intelligence services, criminal hacking groups, and nation-state actors. And I have real-world proof of this. In 2010, Chinese hackers breached the internal systems that companies like Google and Microsoft used to comply with government search warrants. The very legal access infrastructure built for law enforcement became the entry point for one of the most significant corporate espionage operations ever documented. And the hard truth from a cybersecurity perspective, it is nearly impossible to create a backdoor accessible only under certain conditions. Vulnerabilities don't check credentials. They are open to everyone. And here's something that doesn't get discussed enough in the context of warrant requirements and judicial oversight. Governments don't always need a legal process to get your data. They can buy it. The data broker industry sells location history, app behavior, purchase patterns, device identifiers, and social graphs derived from your smartphone usage commercially on the open market. Law enforcement and intelligence agencies in the Five Eyes nations have been purchasing this data without warrant. So where Bill C-22's warrant requirement sounds like a safeguard, it's a one lane on a multi-lane highway. And here's where I'm going to put in the AI dimension. Because 1 year of metadata retained on every Canadian subscriber isn't just a record, in the hands of modern machine learning tools, it's a behavioral map. It can tell you who someone knows, where they go, when they deviate from routine, what communities they're part of, without reading a single message, without listening to a single phone call. That's the architecture Bill C-22 is putting in place. Build the haystack first, use AI to find the needles later, and define needle however the government chooses to. But I need to zoom out here because Bill C-22 doesn't exist in isolation in Canada. It's part of a much larger picture, and that picture is in the Five Eyes Intelligence Alliance. And for those who don't know, Five Eyes is the intelligence sharing agreement between the United States, the United Kingdom, Canada, Australia, and New Zealand. These 5 nations operate, and I'm quoting Edward Snowden here, as a supranational intelligence organization that does not answer to the known laws of its own countries. Now, the Snowden revelations showed us that the Five Eyes nations were collecting data on each other's citizens and sharing it amongst themselves, effectively circumventing their own domestic legal restrictions. A Canadian federal judge strongly rebuked CSIS for enlisting overseas Five Eyes patterns in surveillance of Canadians while keeping domestic courts in the dark. That already happened. Bill C-22 is also part of a coordinated multilateral strategy. The Five Eyes group quietly issued demands requiring providers to create customized solution, tailored to their individual system architectures, capable of meeting lawful access requirements. And the language used wasn't soft. Quote, "Privacy is not absolute," they declared. And the country stated that they, quote, "may pursue technological, enforcement, legislative, and other measures to achieve lawful access solutions," end quote. Bill C-22 is Canada's legislative measure in that same campaign. Now, I want to talk about what's happening to the other nations as well. So in France, legislators recently proposed a ghost user mechanism, a hidden silent government participant added to any encrypted conversation for surveillance purposes. It was only removed after civil liberties and cybersecurity experts raised the alarms about what it would do to the fundamental trust model of secure communications. In the United Kingdom, Canada's closest Five Eyes partner, the government secretly ordered Apple to add a backdoor to its encryption services worldwide. Apple refused to comply and instead removed its advanced data protection features from the UK users entirely, choosing to accept a degraded product rather than compromise global security for everyone else. In India, the government ordered all smartphone manufacturers to pre-install a system-level, non-disableable government tracking app. Apple refused. Within 48 hours, India walked the order back. Android manufacturers were just left to comply. So the pattern here is every Five Eyes nation is moving in the same direction, but the architecture differs. The legislative vehicle differs. The political framing differs. But the destination is the same: mandatory surveillance capability baked into digital infrastructure. Let's talk about your device for a minute, because not all smartphones are created equal when it comes to a compelled government access, and this matters most than people realize. Apple's business model is built on selling premium hardware. Privacy is a differentiator that justifies that premium, so Apple fights for it, not purely out of principle, but because privacy is architecturally good for their bottom line. Apple built a phone even Apple can't unlock. They've refused government backdoor demands publicly and repeatedly. We've seen the evidence in the UK, in India, and the original San Bernardino case in the United States. Google's ecosystem is different. Google's revenue model is built on data, advertising, analytics, targeting. Privacy fundamentally competes with that model. The result is an architecture with far more access points, more integration with third-party services, and historically, far less resistance to government requests for data. When India issued its tracking app mandate, Android manufacturers complied. So the device choice does matter. Under Bill C-22's compelled compatibility mandate, the question isn't just whether a law exists, it's which devices have the architectural and corporate will to resist. That's a material security decision for every Canadian listening to this podcast. All right, so I've spent a lot of time mapping the threat. Let me talk about what you can actually do about it. And I want to be honest here, there is no single tool that makes you invisible under this framework. But a layered approach significantly raises the cost of surveillance and closes off most of the easy collection vectors. So I'm going to talk about the layered privacy defense stack, and I'm going to break it down in the most important layers in plain language. A VPN encrypts your traffic between your device and the VPN server. Your internet service provider sees you connected to a VPN. That's it. They can't see what you're accessing. Under this Bill C-22, if a production order goes to your internet service provider, what they can hand over is limited to timestamps and a VPN server IP. And this is critical, run your VPN through a provider based outside Canada. A Canadian VPN provider is potentially subject to the same retention obligations as any other telecom. Jurisdiction matters enormously. End-to-end encrypted messaging protects the content of your communications very well under this bill's stated scope. The bill isn't targeting message content, it's targeting identity and location metadata. But what it can't hide is the fact that you've communicated, when you did, and from where. Offshore hosted services. And I'll be transparent here because it's directly relevant to my work at Secure Private Data. Add a jurisdictional barrier to any Canadian production order. A service hosted on a Swiss infrastructure under Swiss law is not automatically subject to a Canadian court order. Mutual legal assistance treaties exist, but they take time, require legal thresholds, and are not the easy surveillance tap that domestic retained data represents. So the bottom line here is the goal isn't perfect invisibility. The goal is raising the cost of surveillance high enough that bulk, passive collection becomes impractical, and targeted collection requires genuine judicial justification, which is how it should work in a democracy. Your cell tower location, by the way, is the hardest data point to protect without physically leaving your phone behind. Your cell radio constantly pings towers regardless of what software you're running. That data is collected on the network level, and under this bill, C-22, it gets retained. So let's talk about the bigger picture. Where is all this heading? Let me close on this, because I don't want to leave you thinking this is just a Canadian story. What I'm watching across Canada, the UK, France, Australia, and the United States is the systematic construction of a surveillance infrastructure that is unprecedented in scope. Not because any individual government has declared authoritarian intent, but because the architecture of mass data collection, once built for one purpose, is available for any purpose. Now, understand the threat model isn't just government reads your messages today. The threat model is a database of 1 year of every Canadian's metadata combined with AI pattern analysis, combined with compelled backdoor capability in core digital infrastructure, combined with Five Eyes sharing that bypasses domestic warrant requirements, all managed by whoever happens to hold political power at any given moment. The safeguard is not the law as written, because laws change. Safeguards written in legislation can be amended with a majority vote. The only real safeguards are architectural, systems designed so that the data doesn't exist to be handed over in the first place. Services hosted in jurisdictions with independent legal protections and encryption that holds regardless of which government is in power. So here's a closing thought. A lock that can be legally mandated to open is not a lock. It's a door with paperwork in front of it. That's why the decisions you make today about your devices, your services, your communications infrastructure, they aren't just convenience choices. They are political choices. They are statements about what kind of digital world you want to live in. And that's the cup of coffee for today, folks. I hope it was strong enough. Links, references, and other further reading will be in the show notes. If this episode gave you something to think about, share it, because this conversation needs to be louder than it currently is, inside and outside Canada. So I'm your host, Darnley. Stay secure, stay informed, and remember, knowledge is your power. Stay safe, and I will see you in the next episode of Darnley Cyber Cafe.